Hello. I want to thank Professor Elena Uvarova and the leadership of the Kharkiv International Legal Forum for inviting me to make these remarks. I am honored to address such an illustrious gathering. I congratulate you on forming the Central and Eastern Europe Business and Human Rights Scholars Association and for putting on this timely conference. This is an important moment in the development of business and human rights in Central and Eastern Europe. Speaking for the editors of the Business and Human Rights Journal, we are excited to see what will emerge from this conference. Especially, we look forward to a special issue of the Business and Human Rights Journal that will focus on Central and Eastern Europe, which will be edited by Professor Uvarova, Professor Beata Faracic, and Professor Jernej Cernic. Professor Uvarova asked me in these opening remarks if I might say something about how legal scholars and scholars from other disciplines, my own being business ethics, might differ in the contributions they could make to the BHR field. Perhaps the best way to understand the differences is the reaction to the promulgation a decade ago of the United Nations Guiding Principles on Business and Human Rights. When the guiding principles came out, lawyers were quick to shout, "Guiding? That is too weak a word. How can we turn these principles into law?" Perhaps the most extreme example of this professional orientation is the quixotic quest for a binding global treaty on business and human rights. By contrast, when business ethicists like me saw the guiding principles, we shouted, "Principles? What principles are these? Do they really accurately describe the true corporate social responsibility for human rights? What makes them morally binding apart from their mere assertion by the United Nations?" This difference in approach underscores the complex relationship between law and ethics. Law, for the most part, incorporates our shared understanding about what is morally right and wrong. Contract law, for example, exists because we think it is morally right to keep promises. Tort law exists because we think it is morally wrong to injure someone. At the same time, sometimes there is no moral consensus, and so the law is unsteady at best. In the United States, for example, the legal rights of the LGBTQI community are far from secure as a result of a lack of moral consensus. More importantly, however, the distinction between law and ethics is important to uphold because the law is sometimes unjust and needs to be changed. For example, the apartheid laws of South Africa, the Nuremberg laws in Germany, and in my own country, the United States, the scourge of slavery and the continuing systemic racism against citizens of African ancestry. In the business and human rights field, lawyers and ethicists need to work together. The ethicists must remain focused on the moral content of human rights because, in part, there are many areas of human rights where the guiding principles offer neither guidance nor principles. What are the responsibilities of businesses operating in China for the massive tragedy of Uyghur oppression? What responsibilities do drug companies have to make COVID vaccines affordable in the global South? The guiding principles offer scant insight into these questions. At the same time, lawyers have a crucial role in the pursuit of justice. Only they understand how legislatures, judiciaries, and government executives work to make a moral idea a reality that can be relied upon by ordinary citizens. In sum, I want to conclude by saying that human rights are moral rights, but if they are to have meaning and impact, they must be turned into legal rights. Lawyers and non-lawyers each have a unique role to play in the BHR community. Thus, let us all join together in saying about the guiding principles, guiding principles. Thank you for the opportunity to speak with you. I wish you a stimulating and collegial conference.